PV 14 defeated. NDP 20. The note here is if this is adopted, PV 15, NDP 21, and NDP 22 cannot be moved. So, any debate on NDP 20? Mr. Davies.
Just for my colleagues and information, essentially it removes the 14-year penalty and replaces it with a $300,000 fine or imprisonment for 2 years less a day for indictable proceedings, and in the case of proceeding by summary conviction, to fines of not more than $3,000 for first offense or not more than $50,000 for second offense.
Okay.
Have a recorded vote, Mr. Chair.
We're not there yet. Mr. Oliver.
Sorry.
Thanking Mr. Davies for his continued efforts in this regard, but I think the same response from our side, that one of the purposes of the bill is to deter illicit cannabis activities and have serious criminal consequences in place for those that are outside of the intended purposes of the Act. And these amendments would restrict the court's ability to apply that judgment. So.
Monsieur le Président, avec votre permission, le même commentaire.
Mr. Chairman, with your permission, the same comment. The lines are 25 and 26 rather than 25 and 24 and 25 as is shown for the French text.
We can check it, but I'll need a couple of minutes.
Okay, we're advised it's because the English and the French paragraphs don't always line up, but we're going to follow up and make sure it's correct.
Well, on the English, sur la version anglaise, ça va, Monsieur le Président.
In the English text, there is no problem, but the French version is not in keeping with the English text, nor is it in keeping with what we've discussed. As it is shown here, the bill would it would have no meaning. So I think that it's simply a typographical mistake, and the lines that you do that are not in the same position.
Oui, j'ai l'impression que vous regardez.
It seems to me that you're probably looking at the lines, the numbering of the lines that is in the center of the document, but the numbering on the right applies to the French version. We start with A on line 24, as is shown in the amendment. In the amendment, line 24 in the French text is an offense, a summary conviction here. This is not what I see. It could be that we don't have the same text.
Je vais comparer mon texte avec le vôtre.
I'll make a comparison. It's quite possible that we do not have the same. So.
All right, thanks very much. Seeing no further speakers on NDP 20, I'm call for a vote on NDP 20. All in favor?
Recorded vote.
A recorded vote.
Monsieur Ayou.
Surprise.
Mr. Yolson. Mr. McKinnon. Mr. Oliver. Ms. Sidhu. Ms. Gladue. Mr. Van Kesseren. Mr. Weber. Mr. Davies. Yeas pour 1-1, nays contre 8-8.
Okay, I declare NDP 20 defeated. Now we go to PV 15. Do we have any comments or discussion about PV 15? Seeing no speakers, I call for a vote on PV 15. All those in favor of PV 15, show of hands. All those opposed, I declare PV 15 defeated. Now we go to NDP 21, and if this is adopted, NDP 22 cannot be moved. Mr. Davies.
Yeah, briefly, this is the second tier of amendments to try to amend the criminal sanctions in this bill to a more, in my view, more reasonable view. It reduces the references to 14 years jail sentence down to 2 years less a day for indictment, and for offenses that are under 14 years currently in the bill, it would replace with summary conviction only. this is a difficult area of the bill, and as are others, and I do have some empathy with the government's attempt to struggle with this, but what animates these amendments are the prospect of a province like Alberta or Manitoba or Quebec, where the drinking age is 18, and I expect that the age for consumption of marijuana may be 18. So you'll have the situation where a 19-year-old could give some illicit cannabis to a 17-year-old, and that 19-year-old would face, under this act, up to 14 years in prison. And while I'm empathetic with the arguments of trying to protect our children, and none of us want to see underage people have cannabis, the reality in this country is that they do. And the reality is after this bill takes place, there's going to still be illicit cannabis produced. And so the question really is, what is the appropriate policy response? What is the appropriate regulatory regime? What is the appropriate response to that? And, you know, having a 19-year-old face a potential jail sentence of 14 years for exchanging illicit cannabis with someone who's 17 strikes me as a continuation of the very prohibitionist and criminalized model that hasn't worked to date, that Canadians, the majority of Canadians, don't feel is appropriate, and is not going to work as an effective deterrent in any event. I would take this opportunity to bring up something that I think is very important with it, which is education. If you really want kids under the age of 18 or 19 not to use cannabis, then we should be pouring money into educating them about cannabis use and what its impacts and effects may be on the developing brain and otherwise. We've heard in this testimony that this government is so far committed what can only be described as a paltry $9 million over 5 years on education. We heard testimony from Chief Isidore Day from Ontario, where, as far as he knew, there was no money given to Indigenous communities in this country for education. And we compare that to Colorado or Washington State, where they're spending that amount every year on populations that are 1/5 or 1/7 the amount of Canada. Now, we did hear the Minister of Health say that this is just the beginning, that there will be more money, but I'm waiting for my colleague, Ms. Gladue, to tell us how many days we are before legalization July 1. We're about 9.5 months, I think, maybe 10 months?
Days.
Thank you. 271 days, Ms. Gladue can be trusted on for her accurate estimate of that. That's not very much time in advance of cannabis being legalized in this country to set out an educational regime. So rather than tell 19-year-olds, if you give illicit cannabis to a 17-year-old, you're going to go to jail for 14 years, I'll bet $1 to a donut to anybody that's not going to have much impact in this country. But educating young people about cannabis use, responsible cannabis use, would be a much better way to go.
Ms. Gladue.
Thank you, Chair. Further to my colleague's comments about the public awareness and education, the Minister of Health did say that the Liberals were on their way with this rollout, but I received a copy of the RFP from Health Canada that's looking for a contractor to put together a public awareness and education program directed at young people and at their influencers, which is what we heard testimony we need to do. And that RFP is not even due with bids until October 16th. And then from then on, you'll have to start putting together the awareness program. And with 271 days left to go, certainly that's not going to happen anywhere near the rush date of July 2018. Now, with respect to the age comment, this was exactly one of the reasons why the evidence we heard was we should raise the age, not lower the age, because 18-year-olds hang around with 17-year-olds and 16-year-olds, and there was a concern that there would be transfer of marijuana to them, whereas the other jurisdictions that witnessed, they had 21 as the age. The Canadian Medical Association said that was a compromise between the health harms that kids will receive to 25 and understanding, the prevention. But the idea was that 21-year-olds don't hang out with 16-year-olds, and so there is some prevention that would happen. And so I'm disappointed not to see any age changes in this bill. We see that Alberta's come out with 21, and I think that would have been a better answer.
Mr. Van Kesteren.
And Mr. Davies, you had me right up till about this point, because your argument implies that when a person is 18 everything's okay. And yet we heard testimony that their testimony from physicians, from doctors, that told us that at 25 the brain is still maturing and that damage still can get done. So I'm a little bit puzzled why or if you in fact are saying, listen, the age restriction really shouldn't apply, because as I said, if it's unhealthy for an 18-year-old by way of testimony, or 19 or 20, why would we be so adamant not to allow the 17s to get a hold of this stuff? It's just a little bit of a conflict there. And I don't know if you want to take an opportunity to try to explain that to me, but I'm having some trouble with that one.
Davies.
Thank you for that comment and question. I'm simply making a comment based on the structure of the bill, where this bill sets out the minimum age of 18 for legal possession and use of cannabis. So I'm not commenting that there shouldn't be an age limit. I think there should be an age limit. It's a thorny question whether that should be 18, 19, or 25. We heard evidence, I think, all around that question. My own view is that it should be 19 for a couple reasons. One is, of course, the developing brain. That's one more year of brain development. But second of all, I think your average high school student in this country is 18 or younger. And if you make the age 19, then, in my opinion, it would be more helpful in keeping cannabis out of high schools. The way it is now at 18, half of your grade 12 class will be able to legally possess cannabis, and then that brings cannabis right into the high schools. What I'm really talking about here is what is the proper penalty to Mr. Van Kesteren of what happens then if the age is 18? What happens if you have a 19-year-old who gives some illicit cannabis to a 17-year-old? How do we properly deal with that? And I'm just saying that subjecting that person to a 14-year prison sentence is not the proper way to go.
Mr. Oliver.
Thank you. I just wanted to address this age limit issue again. We've certainly heard lots and lots of our health witnesses say that the age limit should be higher than 17. It should be, I think the CMA said 21. Others have said 25 is really the ideal age. So I think for me, what I heard though is that it's what we can do under federal acts and what can be done by the provinces and territories. So if we move the age limit for possession up, then for someone charged with possession of 5 grams over the age of 17, they would face full adult criminal charges and would have lasting record and would have to go through a much more significant criminal consequence. Whereas if they're 17 or under, it falls under the Youth Justice Act, and the records are sealed, and there's a chance for those records to be, I guess, erased a number of years after the term is finished. So I think for me, it's really important that the provinces and territories understand that there is a potentially a higher age that could be applied to restrict access to marijuana because of that developing brain and the impact on a developing brain. And the provincial territory consequences aren't criminal. They can seize, they can fine and ticket, but it's not a criminal charge for people over the age of 17 at the provincial territory level.
Mr. Davies, just a quick intervention.
Just a point. I mean, one of the interesting parts of this is this concept of the relative harms of tobacco, cannabis, and alcohol. The task force itself, the McClellan task force, found, as has every other major study, that relatively speaking, cannabis has less health impact on anybody than alcohol or tobacco. Now, interestingly, if we're going to talk about the developing brain, why aren't we talking about raising the age of consuming alcohol in this country, if that's the case? Because if the brain's developing and someone can go drink a bottle of scotch every night, if a 19-year-old can drink a bottle of scotch every single night, I can tell you what, after 5 straight years of doing that, they're going to have brain damage. They're going to have cirrhosis of the liver, potentially. They're going to have all sorts of problems. So the issue as well, I think, but we don't criminalize that. But we don't say, well, you face a 14-year penalty in jail because of the developing brain when it comes to alcohol. So really what is motivating my amendments here today is trying to situate cannabis. If we're going to legalize it, then situate it based on the evidence in an appropriate manner, comparing it to other substances that we want to restrict to adults that we know have potential health consequences. It doesn't make any sense, though, to retain 14-year criminal penalties for cannabis and not have those for alcohol or tobacco, but that's exactly what the absurdity of this provision does.
Okay, seeing no further speakers, I'm going to call for a vote on NDP 21.
For recorded vote, Mr. Chair.
Certainly.
Monsieur Ayoub. Mr. Yolson. Mr. McKinnon. Mr. Oliver. Ms. Sidhu. Ms. Gledu. Mr. Van Kesteren. Mr. Weber. Mr. Davies. Yes pour 1-1, nays contre 8-8.
I declare NDP 21 defeated. Now we go to step 3, NDP 22. Mr. Davies.
I'll be mercifully short. It just would amend the criminal provision from 14 years down to 9 years. Again, not as the NDP's first choice, but it has the virtue of allowing judges to give conditional sentences in cases where the Crown proceeds by way of indictment.
Seeing no further speakers, I call for a vote on NDP 22. All in
For
favor?
recorded vote, Mr. Chair.
Yes, certainly.
Monsieur Ayoub. Mr. Yolson. Mr. McKinnon. Mr. Oliver. Ms. Sidhu. Ms. Gledu. Mr. Van Kesteren. Mr. Weber. Mr. Davies. Yes pour 1-1, nays contre 8-8.
I declare NDP 22 defeated.